Section 59 of the Evidence Code deals specifically with the admissibility of opinions provided by experts. This section highlights the importance of specialized knowledge in assisting the court in comprehending evidence or determining a fact in issue. Experts, by virtue of their training, study, or experience, possess knowledge or skill that surpasses that of the average person. This allows them to provide insights that are crucial for a fair and just outcome. The opinions of experts are deemed trustworthy because they are grounded in a deep understanding of their field. These experts, whether they are scientists, medical professionals, or financial analysts, bring a wealth of knowledge to the courtroom. Their opinions are not mere speculation, but rather informed judgments based on their expertise. For instance, in a medical malpractice case, a doctor specializing in the relevant field might be called upon to provide an expert opinion on the standard of care provided by the defendant. Similarly, in a patent infringement case, an engineer with expertise in the relevant technology could be called upon to explain the intricacies of the patent in question. In each of these scenarios, the expert's opinion helps the court navigate complex technicalities and reach a well-informed decision. While Section 59 establishes the admissibility of expert opinions, Section 60 takes a step further. It emphasizes that the opinions of experts, while valuable, must be grounded in facts. This section states that opinions, whether from experts or non-experts, hold value only if they are formed based on facts that the person has personally witnessed or perceived. This requirement ensures that expert opinions are not based on hearsay or speculation, but are anchored in concrete evidence. An expert's opinion is only as good as the factual foundation upon which it is built. For example, a forensic scientist testifying about DNA evidence must base their opinion on the results of laboratory tests and analyses conducted on the collected samples. They cannot simply offer an opinion based on assumptions or hypothetical scenarios. The opinion must be directly supported by the factual evidence gathered during the investigation. Section 4. The Script of Truth, Section 61. Handwriting analysis as evidence. Handwriting, a seemingly mundane aspect of daily life, can take center stage in legal proceedings. Section 61 deals with the relevance of opinions on handwriting. It states that when determining whether a document is written, signed, or executed by a particular person, the opinion of a person acquainted with the handwriting of the person in question is relevant. This provision acknowledges that individuals often develop a familiarity with the handwriting of people they interact with regularly. This familiarity can be valuable in verifying the authenticity of documents. For instance, if a dispute arises over the validity of a will, the court may seek the opinion of someone familiar with the deceased's handwriting. This could be a family member, a close friend, or a professional document examiner. Their testimony can help determine whether the signature on the will is indeed that of the deceased, thus playing a crucial role in settling the dispute. Section 5. Unwritten Rules, Section 62. Opinions on Rights and Customs. Section 62 delves into the realm of unwritten laws and established practices. It states that when the court needs to determine the existence of any right or custom.
Section 63. This section allows for opinion as to usages, tenets, and other relevant matters when specific facts are in question. Simply put, if the case involves customs, traditions, or practices, the opinion of someone who is well versed in these areas can be crucial. For example, in a property dispute involving customary practices, the opinion of a local elder or community leader might be admissible as evidence. This ensures that the court considers the context and nuances that might not be immediately apparent from the bare facts. Next up is Section 64. This section covers opinions on relationships when relevant. This can be particularly important in cases involving family law, inheritance, or even corporate structures. For instance, if there's a dispute over the legitimacy of a will, the opinion of a family member or someone familiar with the family dynamics might help clarify the relationships in question. It's about getting a full picture of the interpersonal ties that might influence the case. Finally, Section 65. This section outlines the grounds on which an opinion can be considered relevant. It stipulates that the opinion must be based on the expert's special knowledge, skill, experience, or training. This ensures that the opinion brought forward is credible and reliable.